All right. You heard it. When you hear the drum beats, you know justice is about to go down. You're listening to the Commish radio show and Legal Standpoint with Michael, Todd, and Calvin Johnson. You know,
Calvin.
Calvin Johnson, the Calvin Johnson. You know, this is what we're doing this weekend. As you know, the show has been catching fire because we've been talking about a lot of injustice in America today. And, you know, we've been catching fire and we've been catching some flack by a lot of people that don't have any degrees. You know, they don't have any degrees.
Right.
But we've been getting like 21,000 views on YouTube, and collectively speaking, we've been blowing airwaves up because we're talking real stuff. And I guess when they first start looking at us, they think we just some brothers just talking. Tell them, Mike.
No. You know what? It has been a last month's show that dealt with the Carmelo Anthony trial. Definitely blew up. I mean, as you stated, over 21,000 views, and you know, a lot of people had a lot of comments. You know, a lot of folks said that, you know, I told it like it was, right down the middle, fair evaluation. Then you had some folks saying, "Oh, Mike Todd, you a sellout." Mm-hmm. Other folks talk about, "Oh, he don't know what he need, you know, what he talking about," you know. So it was all over the gambit. So
yeah.
But I enjoyed it.
I enjoyed it. To say I was the best that was here.
Right.
So I had a question. I had some friends call me, man, that they had to get some people straight about, because sometimes they don't like the truth, you know?
Yeah, no. Something trying to do themselves, or they're trying to make the case fit the facts.
Right.
When we went through this last month, and you know, remember we came in a week early because of the fire that was ongoing with respect to the case, and so we just talked about it, and we talked about possible issues that could be present in appeals. I also talked about, because of course the defense attorneys were receiving a lot of flack, and I said that, hey, one thing that we didn't know is we didn't know what they knew in making the decisions that they made as it relates to the trial. But since last month, there's been some additional activity that has taken place with respect to Carmelo's case. And of course, we want to try to update the audience with respect to that today, and just talk about where it is and where it's going. And, you know, let me kind of handicap with the assistance of Calvin, and of course with Ed just throwing his 2 cents in.
I'm just moderating, brother. I'm just moderating.
I know.
That's just moderating.
I know, but you know what? I mean, I can't say you make more sense than a few attorneys.
So a lot of attorneys, and
so just because somebody has a bar card doesn't mean they got good sense.
I've said that to quite a few attorneys before.
Yeah. So let me kind of just give a recap. If you all remember, last month, Carmelo Anthony went to trial out in Collin County. It was about a week and a half trial. It was a murder case. He's convicted for the death of Austin Metcalf. It had occurred at a track back in April of 2025. And he was sentenced to 35 years in the Texas Department of Corrections, which just caused a big uproar. Now, to that, right? Usually, when a person's convicted, they usually sit in the jail for about 2 to 3 weeks before they do what we call catch. Head down to TDC, go to, you know, they initially go down to Huntsville, process of diagnosing. They're assigned to a particular unit. Do y'all know how long that boy sat there in the jail?
How long?
Not even 24 hours.
Not
even a day.
Not
like
even
he knew.
Yeah.
I'm gonna tell you, I've never heard of that happening at all.
Either.
Where a person was shipped straight to Huntsville within 4 hours of being convicted. I mean, if you look at a person has a 30-day to two things when you convicted. You can file a motion for new trial, saying that there was some issues that were present that may have caused you to receive a fair trial. And also you're able to file an appeal with respect to the case. We talked about the appeal last time. Go over anything. It is something that allows a higher court to look, see, number one, if there's sufficient evidence to support it, and number two, to raise any perceived errors that they see or they allege that may go to say that the trial was not conducted fairly. Now, the one thing you're trying to do those things, and you have tight time frame. You need to be able to talk to your attorney. Talk to your client to find out, what was going on, what tell you, things of that nature. That just made it more difficult for these that are handling the that was
it's not
into
we get ready to do
person. And I believe they said that the night that he was convicted one day, and at 4 o'clock the next morning, they had transported.
See, that's what I'm talking about.
Yeah.
It's within the 24 hours.
Within
not
the
24 hours later. Within the 24 hours.
Within the 24 hours. Well, the one thing is this.
Overnight.
Let's talk about this, and I'm glad Calvin's here so he can add some expertise to this. There has been a new team that has taken over, and that's gotten a lot of publicity. There's been a new team of individuals that have taken over. The old team, which was Mike Howard, Toby Shook, and some other people, I think it was 4 people total, they're no longer on the case. We have an attorney by the name of Russell Wilson that is taken over the case, and he's the lead attorney, and he's being assisted by Michael Ware. He's being assisted by Gary Bledsoe, Brooke Close, I believe it is. She's with the Ben Crump law firm, Sean Deridia, who I know, and then also Justin Moore. So that's the new team that's taken over. Now, I personally know Russell Wilson, and I know some of these other individuals also, but not as well as Russell. Russell and I were actually office mates for about 5 or 6 years before he left to go and be a part of the Craig Watson administration with the DA's office. So he's a very good attorney, things of that nature. And so I'm I am glad that he is an attorney that's leading that effort with respect to to looking at this case. Now, remember last month I said, Ed, hey, this is a hard case.
Yeah, you did.
I said it's a hard case.
You took a lot of flack for that too.
Yeah, I took a lot. Well, you know what? Some people took it the wrong way. When I said it was a hard case, you have to understand, I'm a criminal defense attorney.
You're not a keyboard attorney.
Right, yeah. Keyboard?
Yeah, keyboard attorney. Those
keyboard,
They go like, I feel this.
Right, yeah.
Because they watch L.A. Law and Perry Mason.
Right,
so automatically they know when to object.
Right, yeah. But I'm a criminal defense attorney. And so when I'm a criminal defense attorney and I say the case is hard, I'm saying it from the lenses, from the perspective of the defense. Some people got on there and said that, how's he going to say it's a hard case, when they convicted him and it only took 3 hours. It wasn't a hard case. As if I was talking about it was a hard case for the prosecution. I was saying it was a hard case to defend to the defense about murder, right?
Yes.
Which is the charge that he was looking at, or manslaughter, or anything of that nature. But the thing is this: the new team, Calvin, they filed a new motion for new trial.
Yes.
They had to do it within the 30-day time period with the constraints that we just said that they
Yes.
couldn't have their client. But in addition to those constraints, I have found out from reading the motion for new trial that there were constraints also with respect to information, receiving information as a result of how the trial was being conducted. All right. What I mean by that, Ed, the first thing is this. If you remember on this particular case, order that was introduced or that was entered by the judge, Judge Roach. I said before, Judge Roach for years, I've been in front of Judge Roach. You know, he can be a kind of hard charging type guy. You know, he's the type of guy, if you faint on him, you can't be in there with Judge Roach. He can get very opinionated at times.
Yes.
And if you're not strong enough to push back when
Yeah.
necessary, then you can get stuck.
You can.
Yeah.
So
Yeah, he is. He is.
okay.
Well, I didn't say he was hard. I said that he was hard charging.
Well,
Yeah.
okay. See, that's where the attorney stuff.
If
Where
you're
I'm
not
at.
gonna stand up for your client,
That's what I'm talking about.
You got to be able to
Being hard, you know what? Hard.
hard charging.
Yeah.
Because the thing is
Don't do it
this.
to me,
This because wait a minute, I've had proceedings
right?
where when we started, he was one. You know, he had a certain opinion in his mind of how things were going to go. And when presented with additional evidence, right, he
Backed up.
right,
Mhm.
and so from that standpoint, but I had to do what? End in the gap
yes,
and be able to present my case separate and distinct from how he have expressed how he thought it was, but he was, and make a determination of, I see now, and he denied the state's application, and that I'm speaking of.
So you can't go in there south.
You can't go in there.
have a strong resolve.
Okay.
When you feel a particular way, you're gonna have to stand your ground. If you believe that way, even if he starts maybe in another direction, he feels like he wants to go. You need to make sure that the direction that you want him to go, that you lay that out, and that you stick to that, so that he can at least see your point of view. If you're going to just back off because he wants to go another direction, that's not the place that you're going to get where you need to get.
Without a doubt. But this say, so he entered this gag room. So that meant that none of the participants in the trial, the defense attorneys, the prosecutors, they could talk about the case. And when you got a high profile case, that's usually not out of the ordinary for that to happen. But as I was for new trial, Calvin, it was some things that I didn't know about. And remember, folks, when we talked about this last month, I kept saying, hey, look, we don't know, attorneys know.
Right.
So I can say what motion is going to, if you would not report anything that you have read to anybody. So, I mean, I've never heard of that. I've never heard of that. Now, in addition to that, it turns out that the pertinent pretrial hearings, and this is what happened. I know Calvin knows this, but you probably don't.
We're going to do this all day long. Well, move your mic to the middle. If I'm going to be insulted, I want to at least hear it.
Wait, what you mean? You can
move it right here.
Okay, all right.
Okay.
All right.
Go ahead.
So the thing is,
I'll allow
this.
it, counselor. Go ahead.
Okay, so the thing is this: when you have pertinent pretrial matters, as an attorney, you file pretrial motions. And then what happens is that you have to have your client there. You come in, you come before the court, and you go through your motions. If you have evidentiary motions, you call witnesses, things of that nature.
Mhm.
Let's say if I'm trying to do a motion to suppress, calling witness officers. Some type of discovery, if I'm trying to suppress a search warrant or something like that, I'm going to have witnesses, right? All of those things take place on the record.
Mhm.
And on the record means we're sitting in open court, right? Where everybody can walk in and hear and see. We're in open court. And also we've got a court reporter that is taking down everything that's said. So there was no mistake with respect to any agreements that are made. There's no mistake as it relates to court's rulings. There's no mistake as it relates to the factual findings that the court makes to support its rulings. All of this is on the record, all right? In this particular case, the file was in the judge's chambers. The district clerk has no idea what's being filed, and no pretrial hearing was on the record. None. Now they had some conferences about pretrial motions that were done what? In chambers. In chambers. So that means we went to the back, or they went to the back, and they just talked amongst themselves.
Not on the record.
Not on the record. Now, I've had pretrial hearings in chambers. There may be some interest, it might be something where it's a child sex case or something, and you really don't want all the information just blasted out.
Mm-hmm.
The court will make a determination that, hey, we're going to do this in chambers. But you bring the court reporter back in chambers, and the court reporter still takes down everything that's been taken,
Mm-hmm.
that's being said. Why is that all important now? Because in this particular case, the defense and the state purported to enter into an agreement about what we talked about last time, the extraneous offenses. They were going to do what they have termed a trial. One was going to go in facts of character or bad acts or criminal of the Moncrief Metcalf, the Metcalf boys, nor was anybody going to go into character, reputation, or bad acts with respect to Mello Anthony. That was supposed to be the agreement.
So nobody can talk about anything they've done prior.
Right.
That's been messed up.
Right. Well,
That was the agreement.
That was the. Now the thing is, I've it's long and hard. You have to weigh what's coming in against the other people versus what's coming in against yours. Cancel the trial listed that there were 3 types of information with respect to the Metcalf boys. And it was Austin, and I believe his brother's name is Hunter, I believe it is.
Correct.
And so there was 3 types of information that could come in against them. They said that they were known for violence. They said they were known for bullying. And they also said they had instances of racism. Now, when I see those 3, now I don't know what all of the things were, right? But when I see violence, bullying, and racism, and my client's Black, right? And it's uncontroverted that Austin was the first aggressor, right? Then there's got to be something really bad for me to agree that I'm not going to get into that on their side. You follow what I'm saying?
Mm-hmm.
And actually, I'm leaning not to.
No, I'm leaning not to.
I'm leaning not to.
There would have had to be something really bad on the other side. And that's what I kind of was like, well, it had to be something really bad for them to make the agreement. But I still wouldn't have made the agreement because it's essential to me proving my self-defense argument.
Right.
I just wouldn't have done it.
And Mike, that's what we were talking about when we were on the air last time. You said, well, we don't know what they have.
Right. Yeah, we don't know what they have.
And you were saying it must be really bad then.
Well, yeah, I did. But the thing is that now I at least know what the subject area would have been with respect to the individuals, right?
But the bullying and the racism.
Bullying and racism and the violence, right? And it sounded as if this had been going on for a long period of time. Mm-hmm. Now, this is the thing. This whole agreement, right? It breaks down because the state took the position in trial after it's, from reading the Mike Howard's affidavit, it looks like they were on notice that Anthony was going to testify. And if it was a clean deal, right, where we're not going into their extraneous offenses, and we're not going to go into mine, right, then that would have included when I testify, you not going into mine. Because when you were putting on your witnesses, your being the state, I could have cross-examined those people with respect to instances of bullying, violence, or racism, right? And I could have put on additional witnesses in my case in chief as the defense, right? So what happens, they get to the second half of the trial where it's the defendant's case, and then the state takes the position if Anthony testifies, then he's putting his character in the issue, and he can go into the extraneous. After the defense had adhered to agreement in limiting their cross-examination of the state's witnesses. Right? So you kind of see that kind of speaks of some bad faith there. I've been following the deal because I think that it's evening out. And then when I put my guy on to testify to raise his self-defense issues, right? You're saying, oh no, we're going to be able to go in this case. I mean, we're going to be able to go into these extraneous offenses. So that, but I want to get back to one thing though. I just about why I thought I would not have agreed to this agreement. All right. Now, in addition to the subject matter that the three guys were, right? That three guys. The defense also had limit witnesses they call, so it would not open the door for these extraneous offenses to come in.
Say what?
They had to so strain with it as it relates to the epilepsy. It may have raising self-defense. It's a reasonable person standard in the position of the defendant. All right. Yeah. So it's not what a reasonable person, any reasonable person would do. It's a reasonable person standard for that person. Mm-hmm. So if I got a pacemaker in my heart, right, and somebody pushes me in my chest and I'm older or whatever, right, then that could be something that could cause death to me, correct, right? Versus somebody that's just a young athlete.
Right.
Yeah, so you have to be able to have something, right?
Because I'm compromised.
Right.
Which goes to what some folks are saying on social media when they say, look at this guy, he's really big, meaning Austin.
Right.
And then you have this this guy who's sickly.
Right. Well, yeah. So the F is left. So the thing is this. So as the defense attorney, right, I'm giving up being able to bring up bullying, violence, and racism, and then also have to give up my neurologist, right? In addition to that, they had another expert that would have been able to come in and testify about the development of a young man's mind. Because there's a brand of science out that's showing now that says that a male's brain is not fully developed to make rational decisions, right? Till they probably about 26, 27 years old. So they indicated in a motion for new trial that they did not call that person because they did not want to do what? Open the door. That's a whole lot of stuff to be given up, right? So unless to me they had some Jeffrey Dahmer type stuff, which we know that's not the case, because he ain't never, there's no criminal cases that we're aware of, unless it was something in juvenile or something. Now, maybe something from I don't know, right? But right now, I'm sitting there thinking, I'm like, that is a whole lot for me to sacrifice to try to keep this stuff out. I would probably rather dirty up everybody. You follow me? I'm going to dirty them up. If y'all want to dirty me up, but I need to get in, especially the stuff about the neurologist and also about the brain development.
Like, you know what that sounds like?
What's it sound like?
That sounds like the Luca trade.
So what trade?
That sounds like the Luca trade.
Yeah, that does, doesn't it, man?
We're going to do this more often with all three of us like this.
Yeah, that is. Yeah, that's
good
pretty
analogy,
good.
ain't
Yeah, that's pretty good one.
We've been good with the analogies.
Yeah. That's like Luca, baby. Yeah.
You gave up a lot.
But the thing is this. The bottom line is that it didn't work because the state took the position that if he took the stand, that all the extraneous offenses would come in against him anyway. So, I mean, what was the benefit of it? Except that my case was limited, right? But the state still got to put on everything they wanted to as it relates to that particular deal. And you know what? When you read this affidavit from Howard about what was going on here, right, that day, it's really mind-boggling. Howard, listen to me. I'm about to tell you.
For those folks that don't know who Howard is, tell them again.
He was the attorney that was representing Anthony. Now, and like I say, in his defense, and the only defense I can give him at this point is I don't know what the extraneous offenses against Anthony were. I don't.
Being late returning the library book?
Well, that could be an extraneous offense. Yeah,
you mean they could go that ticky-dock with stuff like that?
Yeah, they do. They go through school records sometimes. I had one case one time where they tried to say my man cut line his lunch.
Wow.
I mean, they had other stuff. But
I know, but
they,
that was it.
But they put it in there.
They put it in there.
And so I was like, come on, man. Y'all saying they cutting line in lunch? What's that supposed to be? Oh, he's a defiance of authority. Yeah. He doesn't want to follow the rules. He's a rebel.
He's a rebel.
Yeah. So stuff like that. It was just, that's just crazy. But listen, though, I'm not finished. I'm not finished. Because this is what's mind-boggling. When the state said that if he took the stand, that they would be able to cross him on extraneous offenses to try to salvage the deal. The defense attorney showed his direct examination outline to the prosecutor to be able to go through and see what questions he could ask versus what questions he couldn't ask to be able to not open the door for these extraneous offenses. I have never shared my outline with the prosecutor and have the prosecutor have veto authority over what I'm about to ask.
So this I'm gonna ask.
What you think about that?
Oh, that's sure.
Yeah. Oh, that was gonna hurt me. No,
Yeah,
you
no.
can't. Yeah, you can't ask me that.
So, attorney.
This is the thing. Conference had 7 charges, right? We ended up, he was looking, if we had gone to trial, he probably would have got about 50 and had to do day for day, right? We worked out a deal where we were going to do punish. He was going to plead guilty to 1 offense. And upon completion of that one case, the other cases were going to be dismissed. All right. Well, as we going through the one case, they're putting on the other 6 cases as extraneous offenses during the punishment. So I'm contesting some of those extraneous offenses because, number one, some of them weren't true, right? The state got upset that I was contesting the extraneouses, and they said that wasn't a part of the deal, that I was supposed to just admit to all the extraneouses, right? And that the court would take that into consideration. I said, well, we never talked about that. I said, the discussion was we were going to plead to this one, and y'all were going to dismiss those, even though you could bring them up as extraneous offenses. But I still test them.
I follow you.
After they asked for 40 years on my guy, right? My guy got 15, right? So they weren't happy, right? So the next thing they say is, well, I say, well, where are my dismissals? And they like, well, it's up in the air whether we're going to dismiss the cases or not. So and so, right? And so I say, well, that's not our agreement. And so they were like, well, I believe that is. I said, no, that's not our agreement. So I said, Judge, we went through our agreement when we did the plea. I got my client to acknowledge what his understanding was of the agreement. I stated my understanding of the agreement, and I had the prosecutor outline on the record her understanding of the agreement. And they were all the same. Judge went back, looked at the transcript, and said, yeah, that's what the agreement is. The thing is this, Ed, it was on the record. It wasn't something that we talking about in the back where somebody may misinterpret what's being said, right? It's on the record.
So, Mike, let me stop you right here. This is exactly why I wouldn't have made that deal, because it's not on the record. When you don't do a deal that's on the record, you put your client at risk, you put your own license at risk, you put the whole process at risk. Then when they go back and look at what happened, now you're going back and have to do affidavits. Now you're going back having to clean stuff up. There's no way in the world that I'm going to put myself at risk or my client at risk or my reputation at risk or my future cases at risk by making that kind of deal. I just can't do it. I would have to put everything on the record. You have to protect your license and you have to protect your client. Look at the situation that Todd just explained. When you don't put something on the record, look what can happen.
Right. And the thing is this, and I've had trials where my client had extraneous offenses, and then you had the complainant with extraneous offenses. And you know what? Sometimes you just got, hey, everybody's in the mud, right? Mm-hmm. So you just got to put it on the line and just let it roll from there. But the one thing in that situation is, at least they say, well, dang, everybody crazy. Everybody tripping in this case. You follow me?
And one other thing, Mike, when you are an experienced defense attorney, you know how to put the stuff out there the way you need to put it out there to lighten it, to soften the hit. So my deal would have been just to soften those extraneous offenses and then to be able to highlight what the Metcalfs had done wrong to make my client do what he felt like he had to do. We know how to do that. I mean, we're experienced at doing so.
Well, that's true. Now, I say all that. That may have led to a different result in the case, but it's still, the analysis that I did as it relates to the substantive issue, right, that was on the murder case, those are still there. So the case still would have been a hard case.
Yes.
But the thing is that from what I'm reading right now, I would have just had to go with the Donnybrook approach rather than I'm just trying to slide through approach. One thing that I've learned in the years that I've practiced, and I got this from it's an attorney that's out of Houston, man. I can't remember this day. It may be Rusty Harden or somebody, handled a lot of cases. He said, you got to embrace the ugly baby. You follow me? And I've done that more. Where I've embraced something that looks bad, something that looks, like it's something that's going to doom me, right? I had a case in Tyler where a guy was a part of the constable's department. Went in, forcible entry and detainer, and some of the constables started stealing stuff, right? And made some statements that made it seem like he was a part of the theft ring.
Mm-hmm.
But there were other stuff that showed he wasn't. So I had to do what? Rather than run from his statement,
Mm-hmm.
I embraced it,
Yes.
brought it in to give it what you said, Calvin, a different interpretation. He could have meant this, couldn't he?
Mm-hmm.
And based upon his actions, that would have been what he meant. That's how he comported himself as it relates to his conduct that day.
And then what happened with the case?
Not guilty.
Had a situation.
Wait a minute.
Yeah.
In Tyler, Texas.
Yeah.
Not guilty in Tyler.
That's correct. And that's amazing. Listen, I tell people all the time, I had somebody recently who shot a job. Maybe there were some circumstances that maybe she did something wrong, but the other person did some things wrong, and I was able to, how you do?
What you got?
Hey, man, I just had to, hey, that's that old clip, dog. Jab you a little bit, man.
You guys should see what we say off.
I'm trying to tell you, knockout blow, knockout blow.
Off record.
Now, wait a minute, but we've been talking about a lot of stuff, right?
Yes.
But there's, as I told you, it's a motion for new trial that's on file.
Right.
The issue that I believe that's the best issue for this motion for new trial ain't got nothing to do with what we're talking about right now, except for the stuff of closing the file cabinet. I mean, the filings and things of that nature. That is one thing, right? That this motion for new trial has alleged to say that this trial was not a public trial. All right? Now listen to me on this, Ed. A defendant has a Sixth Amendment right to have an open and public trial, right?
Right.
But the state of Texas and all citizens also have an interest in a trial being public, because we don't do so over in Russia, where you try some secret, come out, he's convicted, and then shoot him in the head this morning, right? Also, individuals to ensure the sanctity of the proceedings, right? It allows the defendant to see that those individuals within the community are there, and this trial garnered interest from all over the country. So this motion for new trial says that when you look at the fact of taking control of the filings, no hearings being in open court, right? And then the gag order that was imposed. And there was also a schedule as it relates to who could come into the courtroom and how and at what time. If you were a person, it was only a 70-seat courtroom. They had like 15 seats that was supposed to be for the defendant's family, 15 seats for the plaintiff's family, for the complainant's family. There was court personnel that had to be in there. So there was only 24 seats that were allowed for people just to come and watch this open trial, right? Well, what happened is the judge entered an order that said that not only his courtroom would be closed, right, except for when they started the proceedings, but the entire courthouse would be closed.
Yep,
In addition to the whole parking lot.
that's true. I got as close as the parking lot. I was there.
And so you could not be on the parking lot before 6 o'clock. And then what would happen is those individuals that were coming to watch the trial, including Carmelo's family, they say his aunts and his grandparents couldn't even get in to watch the trial.
They were out there with us.
You follow me?
Mhm.
And so, and then you had to get there at a certain time,
Yeah.
line up, right?
Because I had a guy do it. I had, my other podcast partner had to get there at 5 a.m., 4 a.m., 4:30
Yep,
a.m.
I've heard people there.
Right.
At 3.
Yes.
And the thing is
Yeah.
that they could only come into the courtroom at 8:50, and court was starting at 9. So that's a 10-minute window. And if you went into the courtroom, right, you couldn't leave.
That's it.
But if you did leave, you couldn't come back.
Correct. No
Right.
in and out.
No in and out.
Like being at a club.
Right.
No
No,
in
in
and
and out. Yeah. Man, count knowledge and son. No in and out.
Yeah.
Yeah. Had to pay again. Yeah, you couldn't even get a hand stamp.
No handstand.
No in and out.
Telling the age, Mike. Telling the
Yeah.
age.
Man Camp out. I was
Man
talking
Camp
to a
out.
brother about Man Camp
Yeah.
yesterday.
Mhm.
Calvin don't know nothing about
He don't know
that.
nothing about
Yeah,
that.
he too young.
Yeah.
He too
You
young.
got-
He
you
too
got
young. But the thing is, so this motion for new trial is 63 pages long. All right. All the stuff about the agreement, all the stuff about the jury charge, all that stuff. Okay. You know how many pages that took up?
I mean,
About 15. The other 40 something pages, the public trial, saying that this was not a public trial based upon the court's orders. Now, why is that important? Now, I'm going to tell you. Remember last time, Ed, I told folks these appeals can be illusionary, right? Because the court come up, even if they find that something had been done wrong, they can come back and say, oh, that was harmless error. It would not have affected the outcome of the case,
Mhm.
right? You know, that's the reverse of Trump, right? That's the reverse of Trump. Even though it wouldn't affect the outcome of the election, he just say it's, but the different thing is this, that the trial was not open to the public as it should have. There is no harmless error that applies to it. If they find he could get a whole trial just on that. The thing is, there's a case, and the case is called. Yeah, I got you. This is called Walker, and in Walker, there are 4 things that they have to do. I asked them say that I have an interest that needs to be addressed, right, by closing or limiting public act of that nature, gag order. And that is with the defense, not the state. This was all. The judge has to articulate reasons of why he believes the case. He has to take into consideration less drastic alternatives. It making a determination of I should this, right? And there's one other factor that the thing is this. There's nothing in the record. His findings.
Because he kept
He kept everything.
Yeah, he kept everything himself.
He kept everything himself. That could be he had 2 cases. One came out in January, right?
Mm-hmm.
That plays out. To do with the 3 argument, and it may have teeth. Now, the one issue that kind of pops up on that is, did the trial attorneys file any objections as it relates to this? That could affect it.
Mm-hmm.
The brief, the motion for new trial said that the trial attorneys would not have been cognizant of everything that was going on because the judge had delegated some of this access decision making to court personnel. And so they weren't aware of people being excluded, things of that nature, until after the trial was over with. So that they make the contention in the motion for new trial that by bringing it up in the motion for new trial preserves it as it relates to objecting to it. So we'll see how that plays out. But it's a very novel theory. It's one that's good as it relates to the current law. And so I think that gives them some hope that maybe something can happen from that. But even if they got a new trial, right, we still dealing with
all those issues,
the evidence in the trial.
And that's what people need to understand as defense attorneys. It's still going to be a hard case. And we're not saying it's going to be a hard case because, oh, y'all not going to fight for him and y'all don't believe in Carmelo. It's not that situation. It's just as experienced attorneys, we know what hard cases look like. Mike's been doing this longer than me, been doing this way longer than me. And I'm about my 25th year. So, Mike been doing it longer than I have. So
hey, man,
he saw one more trials than me.
Don't tell everybody, man.
Hey, man, you experienced, but you experienced, man. You look good, too. Man.
Embrace the ugly baby, Mike.
You look good, too.
Embrace the ugly baby. Come on, man, just embrace it.
All right, man. Okay,
yeah, okay.
Come on, man.
But at the same time, you do have to understand that we've been doing it. This is all we do. This is all we think about. We eat, sleep, and live it. So at the end of the day, you definitely have to understand when you hire attorneys like us, listen to us. We're not just here, we're not just YouTube folk. We're not just podcast folk.
Yep.
We do this for real.
Right. Yeah.
As we said when we first started this podcast, man, we've been doing it now, about 6 years now?
Right.
Yeah.
Maybe longer than that.
Yeah.
I don't even know.
Yeah, it's been a long time. Before we were with Fishbowl.
Right.
Yeah, we're not just 2 brothers just talking shit.
Yeah. From
you know why.
Right.
That's it. So
Yeah.
that being said, I think we're almost out of time. You guys have any closing remarks to where they can find you on social media and so forth, so on?
Well, what the thing is this, man. They you just got to keep the faith, got to keep fighting. You got to look at the case, but you also have to understand what victory is.
Mm-hmm.
Sometimes people think victory is only being able, walking out the door, right?
Mm-hmm.
Sometimes victory is getting something that I can handle.
Exactly.
Something that I can do
Yeah.
that I still have life in front of me.
Bingo.
Yeah,
Like getting
yeah,
probation when somebody gets shot in the job.
Yeah. Because I got
That's pretty good, man.
Wait a minute. I got folks walking around too,
I know what you mean.
case. Yeah,
exactly.
You ain't gonna tell me where this is at because I don't want to go there. Man. Well, thank you for tuning in. Tune in for Legal Standpoint on YouTube, the Commish Radio Show on YouTube,
right,
Instagram, X, and also TikTok.
Right.
TikTok. What can they find you
at? They same place as Facebook and Ed Gray, the Commish Show. Once a month we're here, and then on Watching the World 777 every Sunday night at 6 p.m. We're doing a show called the Weekly Legal Review. So that's where they can find me at.
All right, and you know what? We gave some good information today. We want everybody to share this like they did last time.
Yes.
Let's see if we can go over 25,000.
25.
25. We over 21,000.
We're keeping it alive at 25.
Yeah. Let's go over 25,000
yes.
views on this.
Let's
all
get
right.
it.
All right.
Way to go. Legal Standpoint. Appreciate you.
Donate. That button up there ahead of us, donate as well, okay?
Donate. Well,
Yeah,
I ain't know
donate.
about. I ain't got no money for donate. What you talking about? hey, we got to go off. I got some talking we got to do now.
Hey, embrace the ugly baby. Embrace the ugly baby.
Hey, thanks everybody
Thank you,
on
Nick.
Facebook.
Appreciate it.
Tell us when we off. Don't move yet.
Who was that masked man? You mean you don't know? That was no masked man. That was the Commish. Saturdays from 5 to 6 p.m. on the Fishbowl Radio Network. Hey, how you doing? This is Ed Gray of the Commish Radio Show. Stay tuned and tune in and be up to speed on everything in social justice, human rights, and politics on the Commish Radio Show, airing every Saturday, 5 p.m. on the Fishbowl Radio Network. Jump in.